But basically, why are we looking at free movement regimes? And what are free movement regions to begin with, right? And the idea came from the Global Compact on Migration. If you look at Objective 5 of the Global Compact, it's arguably the most important objective of the entire Global Compact on Migration. Remember, the Compact is about making sure or trying to ensure that migration is orderly, regular, and safe. And obviously, if that is the case, we need legal pathways for that mobility to take place. And within the 23 objectives of the Global Compact, Objective 5 is actually the one in which states are committing to enhance and to create more legal pathways towards facilitating mobility of people around the world. And the Compact talks about 3 different mobility pathways. The first one is visa liberalization. The second one is labor mobility arrangements. And the third one is free movement regimes. We know, obviously, what is visa liberalization: 2 or more countries, either bilaterally, multilaterally, or unilaterally, deciding that nationals of other countries, of particular other countries, or a selected group of other countries, do not need a visa to enter for short periods, usually for the purpose of tourism or business purposes, etc. We know also what labor mobility arrangements are. There's a big database by Chilton and Woda, who have looked at bilateral labor agreements, which are the most common when it comes to labor mobility arrangements, although there are also multilateral labor mobility agreements, of course, but bilateral labor agreements are the most common. And, a number of colleagues, not only Chilton and Woda, but a number of other colleagues have been working on these ones. But we know very little about free movement regimes. Of course, this doesn't mean that we know nothing. We know a bit, because some academics and also some international organizations have been producing a bit of work on free movement regimes. Obviously, we know a lot about the EU free movement regime. We know something about other free movement regimes regionally, for example, in South America. But there has never been an attempt to map, first of all, to map all free movement regimes. There has never been an attempt to analyze them individually, to compare them. And there has never been an attempt to have a data set where individuals, being those academics or policymakers or other stakeholders, can access all the legal instruments constituting these free movement regimes. And this is precisely what we are doing with this project. We are not looking at implementation. We are looking at what these regimes are saying on paper, as you will see in a second. And this is the first attempt ever to produce this, not only mapping, but also this individual analysis, this comparison, and also this collection of treaties that you can find in the website. So our working definition of free movement regimes, or our common minimum denominator, and this is something I discussed, for example, I remember with Rainer already in 2021 in Vienna. Okay, what is the minimum common denominator of these free movement regimes? And our minimum common denominator is basically treaties. Sometimes, most of the times we are talking about international treaties, or we are talking about a collection of international treaties. In some cases, we have a free movement regime constituted only by one international treaty. In other cases, we have a free movement regime constituted by a collection of international treaties and perhaps some secondary laws. For example, if we look at the case of the EU, which all of you know, the EU free movement regime will be composed of the Treaty on the Functioning of the European Union, a number of articles in that treaty, Article 18, Article 45, for example. It will be composed also of Directive 2004/38, and it will be composed of the Regulation 492/2011 for workers, right? So we're looking at regimes which allow nationals of the participating states to not only enter, but also to reside and to have access to the labor market. So those are the 3 elements that represent our minimum common denominator. Obviously, there are some regimes that go well beyond this minimum common denominator in terms of the rights they provide to those who are moving and residing in the participating states. Not only the European Union, I have to say, but also many other regions, for example, Mercosur, Andean Community, UK, Ireland through the Common Travel Area. many of these regions go well beyond this minimum common denominator. And in some cases, which we try to explain carefully in our website, in some cases we have sort of penumbral cases. And I think CARICOM is a good example, because CARICOM is the one that allows only certain categories of workers, of nationals who are certain categories of workers, to move around the participating states, right? And we always have to make a decision, obviously, with this definition. Sometimes we need to make difficult choices. For example, CARICOM we have included, and we try to explain as carefully as possible, but also with a language that is as easy as possible to understand in the website, why we have included CARICOM and what are the provisions under CARICOM. But in any case, these are our three main elements. And obviously, if you consider these three main elements, the possibility for nationals of the participating states to not only enter, but also to reside and also to access the labor market, we already see immediately that this is different from a visa liberalization arrangement or agreement. And this is obviously different also from a labor mobility agreement, right? Because labor mobility agreements usually only provide for temporary mobility of selected categories of workers, and usually with a very restricted framework in terms of other possible rights. What we are doing in this data set, as I mentioned earlier, is first of all to map all free movement regimes. And I have to say that we're constantly finding new free movement regimes. A few days ago, we realized that there is a new one in some of the Balkan states, if I remember correctly, Serbia, Albania, and Macedonia. They have a new free movement regime since 2022. Again, on paper, we don't care about how that is implemented in practice. We are not looking at implementation, but this is just an example to tell you that we are constantly finding new free movement regimes. This is an area which, even though it has been little explored academically or also at the level of IOM or ILO or ICMPD or other international organizations, nonetheless, it's an area in continuous expansion. And it's very important, obviously, because it tells us something about how mobility is regulated, not only through restrictive measures, but also through a certain facilitation of mobility. This is not open borders. Of course, this is a facilitation of mobility. But anyway, as I mentioned earlier, we are mapping all free movement regimes since 1992 up until 2024. We identify them, we capture their provisions, we are doing coding. In this regard, obviously, we are, following the steps of many previous projects, Global SIT and others that have done this kind of analysis for legal instruments. An analysis or a methodology that is not necessarily very common for legal scholars, but that is becoming more and more common, of course. And we also see how their provisions have developed over time. And we're looking at two particular elements. We're looking at the personal scope, namely who can move and who can reside within these regimes. And then we are looking at the material scope, with what rights can these people move and reside across the participating states. And in that regard, we are looking at the right to work, the right to self-employment, right to work in the public sector, right to access healthcare, education, family reunion, permanent residence, and also political rights. In some areas, of course, as you know, the development when it comes to free movement regimes is very minimal. For example, political rights is one where we clearly have very little in terms of a development of rights in that particular area. And here you have a map. I need to update this map because actually just yesterday, literally, we hired a colleague from King's College, a colleague from Albania originally, who is a lecturer at King's College, who is going to be doing this analysis of the free movement regime that I have just mentioned of Albania, Serbia, Macedonia, right? So in reality, we are talking about 114 countries and 56 regions that we have identified so far. But this map gives you an idea of how common these free movement regimes are globally. Of course, this map could have different colors, and this is something that we are working also with other colleagues in other projects. For example, with the colleagues in a project called MICMOPS, with Adrian Fabel and others, to see also, and with Ettore Recchi, to see how we can, combine different data sets. this could have different colors because, for example, you see there the US highlighted as one country that has a free movement regime. Actually, the US has three bilateral free movement regimes with Palau, Micronesia, and the Marshall Islands, right? These are three independent states, UN members. Okay, we only look at UN member states, and therefore that is why the US is highlighted there, right? And it's also a map that tells you what is there on paper, what is out there on paper. If you look at Central Africa, so the Central Africa Republic, Cameroon, Equatorial Guinea, etc., all these countries that you see there, Angola, that you see there highlighted as having a free movement regime, it is because they are part of ECAS, which is a regional organization in Central Africa, which has a legally binding free movement regime on paper since 1984. But as we explain on the website, even though we don't look at the implementation when it's very, very clear and we have that information at hand, we make a note saying, well, even though this is legally binding since 1984, there are several reports, and we make a reference to these reports explaining that this is not working in practice. Okay, but again, I insist, it is not our task to look at that. It will be the task of others, or it might be the task of a second phase if we obtain further funding, etc. But what we're doing here now is identifying what is legally binding, right? What is law on the books. A few points about what free movement regimes are. This is something I've been doing recently, a project with the African Union, and people have a lot of misunderstandings. Policymakers have a lot of misunderstandings of what free movement regimes are. Well, first of all, free movement regimes are not open borders. I don't know if some of you might disagree, but I think open borders are only a situation where you have two nationalities or more than two nationalities, right? That is the only true open borders that you might have. Here, we are talking about facilitating of mobility. All free movement regimes include clauses that allowed states to either deny entry because of different reasons, usually associated with public order, public policy, but not only, or to expel nationals of the participating states. So this is not open borders. This is simply a facilitation of mobility for nationals of selected countries. They do not necessarily lead to more migration. Again, this is not something, we are not looking at the effects of free movement regimes, but I think it is also important perhaps to look at this further empirically. But there are many examples showing that free movement regimes do not necessarily, sometimes they might lead to more migration, but they do not necessarily lead to more migration. This will be obviously a question more for sociologists, why people migrate, right? But certainly we have several examples. I always like to mention the example of Argentina, which has the best implementation of the free movement regime in South America, actually an implementation that goes beyond the multilateral Mercosur regime in South America in terms of offering those rights also to nationals of countries which are not participating of the multilateral regime. And nonetheless, when you look at the statistics on the number of foreigners in Argentina, 2002, 4.2%, 2022, 4.2% of the population are foreigners in Argentina, right? So we have many examples of, countries that even though they enter into a free movement regime, they are not necessarily going to receive more migration because that is not, that might be one of the factors that might lead someone to move to a country. But certainly we know from the scholarly of sociologists on why people migrate that is much more complex than that. What they do for sure is they make migration regular. The usual example I give is, I could give many, many examples from around the world, but one that is very well known is the example of Romanians in the European Union. Before Romania joined the European Union, there were possibly the largest number of irregular migrants in Europe, primarily in Italy and in Spain. Italy, Berlusconi conducted a large regularization procedure in 2002, more than 600,000 people regularized. What was the number one nationality? Romanians. Spain under Zapatero in 2005 conducted the second largest regularization in Europe in history. More than 500,000 of people regularized. What was the second largest nationality to regularize? Romanians, right? Obviously, Romania joins the European Union in 2007. I know there are some transition periods, but by and large, the possibility of a Romanian becoming irregular becomes legally impossible, and therefore it makes migration regular, right? It might make migration circular. And I think this is something, again, that needs to be further researched. My hunch when it comes to circular migration is that it happens primarily when people have the certainty that upon returning to the country of origin, they might come back to the country of destination. And therefore, I think there are some studies, very, very few studies. There's one, for example, between Sweden and Finland, discussing this issue of circularity. So, I think there is something there that needs to be further explored. There are certainly regional approaches to free movement. This is not a copy pasting of the European model. There is a European model. If you start looking at this, for example, in terms of terminology, in terms of provisions, in the different free movement regions in Europe, you certainly realize that there is a certain diffusion, if you like, of norms. Some of them are very, very clear, for example, between the European Union and the European Economic Area, or the European Free Trade Area, or the EU-Switzerland bilateral agreement. But the same happens in other regions. If you start looking at South America, the Andean community has copied verbatim some of the provisions in the Mercosur Residence Agreement. Or if you look at Africa, many of the regions have very similar clauses and many similar approaches, very similar approaches when it comes to how these regions develop in phases, for example. And they suffer the same challenges of many other areas of international law: lack of knowledge, lack of judicial understanding, lack of jurisprudence in that regard, difficulties in accessing rights which are established by an international treaty, etc. I mean, these are areas that, or concerns or challenges that affect other areas of international law, not only free movement regions. At the end of the day, we are talking obviously about primarily international treaties, either because they are bilateral international treaties, or because at the end of the day, when you create a regional organization, you create it also through international law. And anyway, they create this new legal figure that, we can call this new legal figure the new migrant. I'm writing a paper, I have written a paper with a colleague, with Jacopo Martire, that we are now waiting for publication, or we have submitted it to a journal, where we discuss this figure of the new migrant. Obviously, someone who is not a national, certainly someone who is not a normal foreigner either, in terms of the rights that that person has. There's a lot of literature, of course, in the case of the European Union on this. There is less literature when it comes to discussing other free movement regimes globally. Here you have a map where you can see how this has been developing since in the last 30 years, and you see how more and more countries have been joining these free movement regimes, how this is something, an area of international law that is under continuous development. We might not have, dozens of new legal instruments each year, but we certainly each year have developments in the area of free movement regimes. And in fact, when you look at this map and you zoom into a particular region, for example, Latin America and the Caribbean, which are two regions for which we have finished our coding, and you have all the information in the website, you can see certainly that there has been a massive development. So when you look at the sheer number of free movement regimes in this particular region, Latin America and the Caribbean, we're talking about 33 countries. Well, we have now that 25 countries out of these 33 countries in this larger region of Latin America and the Caribbean are part of a legally binding on-paper free movement regime. Actually, I will say that by and large, these free movement regimes are working pretty well. And you see a clear development, right? Nothing in the 90s, and then beginning with Argentina, Bolivia, Argentina, Peru, bilateral free movement regimes in the early 2000s. Then you see Mercosur Residence Agreement, Andean Community, CARICOM, Organization of Eastern Caribbean States, etc. So you see a clear development in that regard in the sheer number of legally binding free movement regimes at a given point. You also see a clear development in terms of the individuals who can move, or the beneficiaries for free movement regimes. Again, here you have an example from Latin America and the Caribbean of who can move and reside in other countries. We are dividing between those who are economically active, or those who are workers, and those who are not economically active. So you see, for example, in the case of Latin America and the Caribbean, the provisions allowing settlement of non-economically active nationals of participating states, again, on paper, are quite developed. So we see a clear development in terms of the personal scope of these regimes. Um, Here you only have an example of free rights, just to give you an indication that obviously there is a great variation in terms of how each regime is dealing with particular rights. So we have very little on political rights. You only have one regime there, which is the Andean community, which has political rights in domestic elections for nationals of the participating states who obtain permanent residence under the free movement regime. They can do that after 2 years of residence, and at that point they obtain political rights in municipal elections, but nothing else there. Actually, globally, the only other examples that I have found, that we have found, are obviously the European Union, the common travel area between the UK and Ireland, and then the bilateral regime between Russia and Belarus, where there are some political rights enshrined. Then you see, for example, family reunification is quite a prevalent provision, quite a prevalent right in the various free movement regimes. Again, here I'm only discussing Latin America and the Caribbean. And then a general provision on equal treatment for nationals of the participating states is also very prevalent. You can see it in every single of the 9 regimes which are legally binding on paper today in Latin America and the Caribbean. When I'm talking about Latin America and the Caribbean, obviously I'm talking about South America and the Caribbean, just to clarify that there is nothing on Central America, or Mexico is not involved in any free movement regime. And this is a graph that is a bit tricky for me to explain, because it's something that Luke is doing, but it's just to give you an indication that if you look at this also throughout the years, the beneficiaries, the personal scope, in other words, of the regimes is also increasing. The rights, you see quite not a dramatic increase in time, but also quite a steady increase, slowly, but always moving towards more rights. And this has to do with the fact that we code in phases. So whenever there is a change in a particular regime, in how a particular right is regulated, or in how in which nationals of the participating states benefit from the regime, we code a new phase, right? And therefore we can track how these regimes have been developing over time. And then Luke has also created this idea of restrictions. And even though you see also an increase in restrictions are obviously provisions that allowed member states or participating states, state parties to these regimes, to deny entry or to expel. And you see also that even though there has been an increase, it is not very stiff. Okay, this is perhaps the slide that I have more difficulties explaining. This has been created by Luke. But this is just to give you an indication of the things that we can do, or that you might be able to do if you like in the future. Obviously, this is all open access with this free movement project. And let me see how. Yeah, let me just quickly go very quickly, just in 2 minutes, show you the website perhaps. So I'll stop sharing here and I'll share again to show you the website in 2 minutes. And then I conclude basically. So this is our website. So as you can see, you enter into the same map that I have shown you, which we need to update with the Balkan states once we have this new region coded for Europe. We have finished, or we thought to have finished, 4 regions: Europe, South America, the Caribbean, and Africa. Now, obviously, we are realizing that we need to update Europe with this new regime that we have found. But if you click on the regions, you basically have access to first to an introduction to that particular region. So, for example, you click on Africa, you have an introduction to Africa in language, that we try to make as accessible as possible. This is not meant to be, I mean, not necessarily jargon free, but this is not meant to be particularly difficult for someone interested in this area to understand. So you have an introduction, you have further reading always, and then you have the regimes on the left-hand side. The regimes are those that are bilateral and those that are multilateral. When you click on a particular regime, for example, Algeria and Morocco, you have a short introduction to the regime, and then if you continue reading, you enter into the regime itself. The idea with the regime itself is that you have a short introductory test, which is telling you a little bit about where this regime is coming from. For example, Algeria and Morocco is a legally binding regime on paper. It's one that we know doesn't work in practice, but this doesn't mean that it's not legally binding on paper. And this is also very interesting because it tells you a lot also about how difficult it is to denounce this kind of international treaties. For example, right now, there is one between Ecuador and Venezuela that hasn't been implemented for a few years. That was implemented in the beginning when Venezuelans started arriving to Ecuador. And now, only now, Noboa, the Equatorial president, is asking the Constitutional Tribunal how to denounce this international treaty. But it has been there for years without being implemented, which again tells you about how interesting this is in the sense that any lawyer at that point could have arrived before a court in Ecuador, which has an excellent constitution when it comes to the prevalence of international law over domestic law, and could have raised a case arguing that these provisions were directly applicable in Ecuador. No lawyer did that. And this is one of the reasons why we think this project can be useful, because one thing that is very important for us is that here you have the Thailand, the parties, etc. Here you have the international instruments. And let me tell you, some of these international instruments are extremely difficult to find. They have been a dramatic effort to find. Not only in Africa, also in the Caribbean, also in South America sometimes. Many times these legal instruments are not published, even when you have a regional organization, and when you have legally binding decisions or legal instruments by that regional organization, they are not published anywhere. And therefore, you have this, for example, these reports by IOM saying, oh, nationals of this region, they have these rights. Then you go to IOM and you ask them, okay, can you tell me in which article, in which provision, in which treaty it says that? Because I cannot find it. And they say, well, we don't have those legal instruments either. And then you need to go to the secretariat of the regional organization to ask for those. And sometimes they don't give them to you, So this is something that we are doing that I think is very, very useful for people, for, colleagues, academics, but I insist also policymakers, which is that we provide all this, you click on any of this and it immediately gives you access to the particular legal instrument, right? A little bit like it has been done in Global Seed and in other projects, of course. And then obviously we have further reading, again, the same idea. You click on it and you have access to further reading. And finally, before I conclude, well, you have a catalog of legal instruments, which is the same, but just, the whole catalog of legal instruments. You can also enter into the catalog via a particular, regime. And then again, here, something that we also took the idea from Global Seed and other similar projects. We have here the indicators that we are looking at. So we are looking at 30 indicators. We have a code book that we need to publish in the coming. I mean, we are just finishing now the coding of all the regimes. We should finish between May and June, and then we will publish the final regimes and the code book, etc., and eventually, obviously, all the Excels, etc. Or CSVs. Here you have, the different questions that we're asking. So let's say, right to vote. We would like to know how this is regulated in, 2024, and we're going to take, a number of regions. So we're going to take Mercosur, we're going to take the Andean Community, we are going to take, we're going to take Andorra, France, Spain, CARICOM, and the European Union. And you click on search, and obviously it gives you the different provisions, obviously how this is regulated, the year, the regime, the article where this is regulated, and then whenever that is needed, it gives you also further information, right, to facilitate your understanding of the particular provision, right? So as I mentioned before, Andean citizens with permanent residence in another member state, they can vote in the local elections, right? Okay, so that's it from me.